La Costituzione italiana.
The Constitution, Italian. Art. 1. Italy is a democratic republic, founded on work. Sovereignty belongs to the people, who exercise it in the forms and limits of the Constitution. Art. 2. The republic recognizes and guarantees the inviolable rights of man, as an individual and in social groups where he expresses his personality, and demands the fulfillment of the mandatory duties of political solidarity, economic and social. Art. 3. All citizens have equal social dignity and are equal before the law, without distinction of sex, race, language, religion, political opinion, personal and social conditions. It is the duty of the Republic to remove all economic and social obstacles which, by limiting the freedom and equality of citizens, prevent the full development of the human person and the effective participation of all workers in the political, economic, and social country. Art. 4. The Republic recognizes all citizens the right to work and promotes conditions to fulfill this right. Every citizen has the duty, according to personal potential and individual choice, activity or function that contributes to the material or spiritual society. Art. 5. The Republic, one and indivisible, recognizes and promotes local autonomy, and implements services that depend on the state. The fullest measure of administrative decentralization, accords the principles and methods of its legislation to the requirements of autonomy and decentralization. Art. 6. The Republic safeguards by means of appropriate measures linguistic minorities. Art. 7. The state and the Catholic Church are, each in its own, independent and sovereign. Their relations are regulated by the Lateran Pacts. Changes to the treaties accepted by both parties do not require the procedure for constitutional. Art. 8. All religions are equally free before the law. Religious confessions other than Catholic are entitled to organize themselves according to their own statutes, are not in conflict with the Italian legal system. Their relations with the state are regulated by law on the basis of agreements with their respective representatives. Art. 9. The Republic promotes the development of culture and scientific and technical research, protecting the landscape and the historical and artistic heritage of the nation. Art. 10. The Italian legal system conforms to the generally recognized rules of international law. The legal status of foreigners is regulated by law in conformity with international provisions and treaties. A foreigner who is denied in his own country the real exercise of the democratic liberties guaranteed by the Italian Constitution has the right to asylum in the Republic under the conditions established by law. It is not permitted the extradition of a foreigner for political offenses. Art. 11. Italy rejects war as an instrument of aggression against the freedom of other peoples and as a means of settling international disputes. It is allowing, on an equal footing with other states, to the limitations of sovereignty necessary for an order that ensures peace and justice among nations. It promotes and encourages international organizations having such ends. Art. 12. The flag of the Republic is the Italian flag, green, white, and red, in 3 vertical bands of equal size. Art. 13. Personal liberty is inviolable. It is not allowed any form of detention, inspection, or personal search nor any other restriction on personal freedom except by warrant from the court and only in cases and manner provided by law. In exceptional cases of necessity and urgency, strictly defined by law, the police authorities may adopt temporary measures that must be communicated within 48 hours to the judicial authorities and, if not ratified by them in the next 48 hours, they are revoked and remain null and void. It punished every physical and moral violence against individuals subjected to limitations of freedom. The law establishes the maximum period of preventive detention. Art. 14. The home is inviolable. There may be inspected, searches, or seizures, except in cases and manner prescribed by law in accordance with the guarantees prescribed for safeguarding personal freedom. Controls and inspections for reasons of health and public safety, or for economic and fiscal purposes are regulated by special laws. Art. 15. The freedom and secrecy of correspondence and of every other form of communication is inviolable. Restrictions thereto may be imposed only by warrant from the judicial authority with the guarantees established by law. Art. 16. Every citizen can move and reside freely in any part of the national territory, except for general limitations which the law establishes in general for reasons of health or safety reasons. No restrictions may be made for political reasons. Every citizen is free to leave the territory of the Republic and return, provided all legal obligations. Art. 17. Citizens have the right to assemble peacefully and unarmed. For meetings, even when in places open to the public, is not required notice. For meetings in public places it must be given advance notice to the authorities, who may forbid them only for proven reasons of security and public safety. Art. 18. Citizens have the right to associate freely, without authorization, for ends that are not forbidden to individuals by criminal law. Secret associations and those which pursue, even indirectly, political ends by military organizations are prohibited. Art. 19. Everyone has the right to profess freely their own religious faith in any form, individually or in association, to disseminate it in private or in public worship, provided that the rites are not contrary to morality. Art. 20. The ecclesiastical nature and the purpose of religion or worship of an association or institution may not be a cause for special limitations in law, nor for special taxation with respect to its establishment, legal status, or any of its activities. Art. 21. Everyone has the right to freely express their thoughts in speech, writing or any other means of communication. The press cannot be subjected to authorization or censorship. Its seizure permitted only by a warrant from the court in the case of offenses for which the law governing the press expressly authorizes, or in the case of violation of the rules that prescribed by law for the disclosure of the responsible. In such cases, when there is absolute urgency and not be the timely intervention of the courts, the seizure of the press can be run from police officers, who must immediately, and never within 24 hours, report to judicial authority. If this does not confirm the 24 hours, the seizure is understood to be withdrawn and null and void effect. The law may establish, by general rules, which are known means of finance magazines. Printed publications, public performances, and events contrary to public morality are forbidden. The law establishes appropriate means for preventing and suppressing violations. Art. 22. No one may be deprived for political reasons of legal capacity, citizenship, or name. Art. 23. No personal or a capital nature may be imposed except on the basis of law. Art. 24. Everyone can take judicial action to protect their legitimate rights and interests. The defense is inviolable at every stage and level of the proceedings. The indigent are assured, through appropriate institutions, the means for action and defense before all levels of jurisdiction. The law determines the conditions and the means for the redress of judicial errors. Art. 25. No one may be withheld from the judge previously ascertained by law. No one may be punished except by virtue of a law already in force before the offense was committed. No one shall be subjected to security measures except in cases provided by law. Art. 26. The extradition of a citizen is permitted only in cases expressly provided for in international conventions. It may in no circumstances be permitted for political offenses. Art. 27. Criminal liability is personal. The defendant is not considered guilty until the final sentence. Punishment cannot consist in treatment contrary to human dignity and must aim at rehabilitating the offender. The death penalty is not permitted, except in cases provided by military laws of war. Art. 28. The officials and employees of the state and public entities are directly answerable, under criminal, civil, and administrative law, for actions committed in violation of rights. In such cases, civil liability extends to the state and public bodies. Art. 29. The Republic recognizes the rights of the family as a natural society founded on marriage. Marriage is the moral and legal equality of the spouses within the limits laid down by law to guarantee family unity. Art. 30. It is the duty and right of parents to support, raise, and educate their children, even those born outside of marriage. In cases of incapacity of the parents, the law provides for the fulfillment of their tasks. The law ensures to children born outside of marriage full legal and social protection, compatible with the rights of the legitimate family members. The law lays down the rules and limitations for the determination of paternity. Art. 31. The Republic assists through economic measures and other provisions the formation of the family and the fulfillment of its duties, with particular consideration for large families. It protects maternity, infancy, and youth, promoting the institutions necessary for this purpose. Art. 32. The Republic protects health as a fundamental right of the individual and collective interest, and guarantees free medical care to the indigent. No one can be forced to a specific medical treatment unless required by law. The law cannot under any circumstances violate the limits imposed by respect for the human person. Art. 33. Art and science are free and teaching them is free. The Republic lays down general rules for education and establishes state schools for all branches and grades. Public and private persons have the right to establish schools and educational establishments at no cost to the state. The law, in fixing the rights and obligations of non-state schools which request parity, must ensure to these schools full liberty and to their pupils scholastic treatment equal to that of pupils in state schools. State examinations are prescribed for admission to the various types and grades of schools or at their termination and for qualifications to exercise a profession. The institutions of higher learning, universities, and academies, have the right to establish their own regulations within the limits established by state law. Art. 34. The school is open to all. Elementary education, imparted for at least 8 years, is compulsory and free. Capable and deserving pupils, even without financial resources, have the right to attain the highest levels of education. The Republic makes this right effective through scholarships, allowances to families and other provisions, which shall be assigned through competitive examinations. Art. 35. The Republic protects work in all its forms and applications. The training and professional advancement of workers. It promotes and encourages international agreements and organizations whose aim is to assert and regulate labor rights. It recognizes the freedom to emigrate, safeguarding obligations established by law in the general interest, and protects Italian workers abroad. Art. 36. The employee is entitled to remuneration commensurate with the quantity and quality of their work and in all cases sufficient to ensure them and their families a free and dignified. The maximum working day is fixed by law. The worker is entitled to a weekly rest and paid annual leave, and cannot waive this right. Art. 37. Working women have the same rights and, for equal work, the same wages as working men. Working conditions must allow women to fulfill their essential family and ensure the mother and child a special appropriate protection. The law establishes the minimum age for paid labor. The Republic protects the work of minors by means of special provisions and guarantees them, for equal work, the right to equal pay. Art. 38. Every citizen unable to work and without the necessary means of subsistence has a right to welfare support. Workers have the right to be assured adequate means for their needs and necessities in the event of accident, sickness, disability, and old age, and involuntary unemployment. Disabled and handicapped persons have the right to education and vocational training. The duties laid down in this article provided for by entities and institutions established by or supplemented by the state. Private assistance is free. Art. 39. Trade union organization is free. The unions cannot be imposed obligation other than registration at local or central offices, according to legal standards. A condition for registration is that the statutes of the trade unions establish their internal organization on a democratic basis. Registered trade unions are legal persons. It may, through a representative unit proportional to their members, enter into collective labor agreements having mandatory effect for all persons belonging to the categories that the contract refers. Art. 40. The right to strike is exercised within the laws which regulate it. Art. 41. Private economic initiative is free. It cannot be conducted in conflict with social usefulness or in such manner that could damage safety, liberty, and human dignity. The law determines the programs and controls so that public and private economic activity is given direction and coordinated to social objectives. Art. 42. Property is public or private. Economic goods belong to the state, to entities, or to private. Private property is recognized and guaranteed by law, which prescribes the ways it is acquired, enjoyed, and the limits in order to ensure its social function and make it accessible to all. Private property can, in such cases provided for by law and with provisions for compensation, be expropriated for reasons of general interest. The law establishes the regulations and limits of legitimate and testamentary inheritance and the rights of the state in matters of inheritance. Art. 43. For purposes of general utility the law can reserve from the beginning or transfer, by means of expropriation and payment of compensation, to the state, to public, or to workers' communities or users, specific enterprises or categories of business entities, which relate to essential public services or sources of energy or monopolistic situations and which have the nature of primary general interest. Art. 44. The purpose of ensuring the rational exploitation of land and equitable social relationships, the law imposes obligations and constraints on private ownership of land, fixes limitations to the extension thereof according to region and agricultural zone, encourages and imposes land reclamation, the transformation of large estates and the reorganization of productive units. It assists small and medium-sized holdings. The law makes provisions in favor of mountainous areas. Art. 45. The Republic recognizes the social function of the mutual cooperation and without purposes of private speculation. The law promotes and encourages them through the appropriate means and secures, through appropriate controls, their character and purposes. The law safeguards and promotes artisanal work. Art. 46. For the economic and social betterment of workers and in harmony with the needs of production, the Republic recognizes the right of workers to collaborate, in the manner and within the limits established by law, the management of enterprises. Art. 47. The Republic encourages and safeguards savings in all its forms. It regulates, coordinates, and controls the exercise of credit. It promotes the access of popular savings to the ownership of directly cultivated land and all direct and indirect investment in the shares of the large production complexes of the country. Art. 48. Voters are all citizens, men and women, who have come of age. The vote is personal and equal, free and secret. Its exercise is a civic duty. The law establishes requirements and procedures for the exercise of the right to vote of citizens living abroad and shall guarantee its effectiveness. For this purpose a foreign constituency for the election of the rooms, which are assigned seats in the number established by a constitutional law and shall be determined by law. The right to vote cannot be restricted except for civil incapacity or as a consequence of an irrevocable penal sentence or in cases of moral unworthiness as laid down by law. Art. 49. All citizens have the right to freely associate in parties to contribute through democratic processes to determine national policy. Art. 50. All citizens may present petitions to both houses to request legislative measures or to express collective needs. Art. 51. All citizens of either sex are eligible for public office and for elected positions on equal terms, according to the requirements established by law. To this end, the Republic shall adopt specific measures promoting equal opportunities between women and men. The law may, for admission to public offices and elected positions, same rights as citizens Italians not belonging to the Republic. Who is elected to a public function you are entitled to the time needed to perform that function and to conserve his place of work. Art. 52. The defense of the fatherland is a sacred duty for every citizen. Military service is obligatory within the limits and manner prescribed by law. Fulfillment thereof shall not prejudice a citizen's employment, nor the exercise of political rights. The regulations of the armed forces are based on the democratic spirit of the Republic. Art. 53. Everyone shall contribute to public expenditure because of their ability to pay. The tax system is based on criteria of progression. Art. 54. All citizens have the duty to be loyal to the Republic and to uphold its constitution and laws. The people entrusted with public office have a duty to perform them with discipline and honor, taking an oath in those cases established by law. Art. 55. Parliament consists of the Chamber of Deputies and the Senate. Parliament meets in joint session of the members of both houses only in those cases established by the Constitution. Art. 56. The Chamber of Deputies is elected by direct universal suffrage. The number of deputies is 612, of which are elected in the overseas constituency. Members are eligible to all voters who on the day of elections have attained 25 years of age. The division of seats among the electoral districts, except the number of seats assigned to the overseas constituency, is obtained by dividing the number of inhabitants of the Republic, as shown by the general census of the population, by 618 and distributing the seats in proportion to the population of each constituency on the basis of whole shares and the highest remainders. Art. 57. The Senate of the Republic is elected on a regional basis, exception of the seats assigned to the overseas constituency. The number of senators to be elected is 315, 6 of which are elected in the overseas constituency. No region may have fewer than 7 senators, Molise shall have 2, Valle d'Aosta 1. The division of seats among the regions, with the exception of number of seats assigned to the overseas constituency, after applying the provisions of the preceding paragraph, is made in proportion to the population of the regions, as shown by the general census, on the basis of whole shares and the highest remainders. Art. 58. Senators are elected by universal and direct suffrage by voters who are 25 years of age. They are eligible to be senators voters who have completed their 40th year. Art. 59. Senators by right and for life unless they renounce being President of the Republic. The President of the Republic may nominate senators for life 5 citizens who have honored the nation through their outstanding achievements in social, scientific, artistic, and literary. Art. 60. The Chamber of Deputies and the Senate are elected for 5 years. The term for each house cannot be extended except by law and only in case of war. Art. 61. Elections for the new houses take place within 70 days from the end of the previous. The first meeting shall take place no later than 20 days after the elections. Until such time as the new houses are extended powers of the previous. Art. 62. The houses shall convene by right on the first working day of February and October. Each house may be convened in extraordinary session on the initiative of its president or the president of the Republic or a third of its members. When it meets in extraordinary session a chamber, it shall be called to also another law. Art. 63. Each house shall elect from among its members the president and the bureau. When Parliament meets in joint session, the President and the Bureau are those of the Chamber of Deputies. Art. 64. Each House adopts its own rules by absolute majority of its members. The sittings are public, however, each of the Houses and Parliament in joint session may decide to convene a closed session. The decisions of each House and of Parliament are not valid if there is a majority of their members, and if they are not passed by a majority of those present, unless the Constitution prescribes a special majority. Members of the government have the right, and when requested the obligation, to attend sittings. They shall be heard every time they so request. Art. 65. The law determines the cases of ineligibility and incompatibility with the office of deputy or senator. No one may belong simultaneously to both houses. Art. 66. Each house decides the qualifications for admission of its members and subsequent causes of ineligibility and incompatibility. Art. 67. Each member of Parliament represents the nation and carries out his duties without a binding mandate. Art. 68. Members of Parliament may not be called to answer for opinions expressed or votes cast in the exercise of their functions. Without authorization from the House to which they belong, no member of Parliament may be submitted to personal or home search, nor may they be arrested or otherwise deprived of personal freedom, or kept in detention, except to enforce a final conviction, or if caught in the act of committing a crime for which there is mandatory arrest in flagrante delicto. Similar authorization is also required before members of Parliament to interceptions, in any form, of conversations or communications and seizure of correspondence. Art. 69. Members of Parliament shall receive an allowance established by law. Art. 70. The legislative function is exercised collectively by both houses. Art. 71. The initiative of the laws belongs to the government, by each member of Parliament and by those entities and bodies so empowered by constitutional law. The people may initiate legislation by the proposal, by at least 50,000 electors, of a draft drawn up in articles. Art. 72. Every bill submitted to one of the houses is, in accordance with its rules, examined by a committee and then by the House itself, which approves it article by article and with a final vote. The rules establish shortened procedures for draft legislation that has been declared urgent. It may also establish in which cases and forms the examination and approval of bills is deferred to committees, including standing committees, composed so as to reflect the proportion of the parliamentary groups. Even in such cases, until the moment of its final approval, the bill is submitted to the House, if the government or 1/10 of the House or 1/5 of the committee request that it be debated and voted on by the House itself or that it be submitted its final approval, with only explanations of vote. The rules establish the forms of publicity work of the commissions. The regular procedure for consideration and direct approval by the House is always followed for bills on constitutional and electoral matters and for those delegating legislature, the authorization and ratification of international treaties, approval of budgets and accounts. Art. 73. Laws are promulgated by the President of the Republic within 1 month of their approval. If the Houses, each by an absolute majority of its members, declare its urgency, the law is promulgated within the deadline established therein. Laws are published immediately after promulgation and come into force on the 15th day following publication, unless the laws themselves establish a different time. Art. 74. The President of the Republic, before promulgating a law, may request the Houses a reasoned message, to deliberate again. If the Houses once more pass the bill, it must be promulgated. Art. 75. It held a referendum to decide to abrogate, totally or partially, a law or an act having the force of law, when requested by 500,000 voters or 5 regional councils. There shall be no referendum on the tax laws and budget, amnesty and pardon laws, in authorization or ratification of international treaties. They have the right to participate in the referendum all citizens eligible to vote for the Chamber of Deputies. The proposal subjected to referendum is approved if he participated in the vote the majority of claimants, and if it reaches the majority of the votes validly cast. The law establishes the procedures for conducting a referendum. Art. 76. The exercise of the legislative function may not be delegated to the government if not with determination of principles and criteria, and only for a limited time and for specified objects. Art. 77. The government may not, without delegation from the Houses, issue decrees having the force of ordinary law. When in extraordinary cases of necessity and urgency the government adopts, under its responsibility, provisional measures having the force of law, must the same day present for confirmation to the Houses which, even if dissolved, shall be especially summoned and gather within 5 days. The decrees lose effect from their inception if they are not converted into law within 60 days from their publication. The Houses may however regulate by law legal relationships arising out of not confirmed decrees. Art. 78. The Houses decide on states of war and confer the necessary powers. Art. 79. Amnesty and pardon are granted with a law approved by a 2/3 majority of the members of each House, in each section and in the final vote. The law granting an amnesty or pardon establishes the deadline for their application. In any case the amnesty and pardon cannot apply to offenses committed following the introduction of the bill. Art. 80. The Houses authorize by law the ratification of international treaties which are of a political nature, or which call for arbitration or legal settlements, or which entail changes to national territory or financial burdens or changes to legislation. Art. 81. The state ensures the balance between revenue and expenditure of the budget, taking into account the adverse and favorable phases of the business cycle phases. The borrowing and allowed only for the purpose of considering the effects of the economic cycle and, with the approval of the chambers, adopted by an absolute majority of its members in exceptional events. Every law that new amounts or higher charges provides the means to address them. The Houses approve every year with law on budget and expenditure accounts submitted by the government. The provisional budget cannot the budget be granted unless by law and for periods not exceeding a total of 4 months. The content of the budget law, the basic standards and criteria designed to ensure a balance between revenue and expenditure budgets and sustainability of the general government overall debt are established by a law approved by an absolute majority of members of each House, respecting the principles defined by constitutional law. Art. 82. Each House may conduct inquiries on matters of public interest. For this purpose, it shall appoint from among its members a committee so composed as to reflect the proportions of the various groups. The Commission of Inquiry conducts its investigations and examinations with the same powers and the same limitations as the judiciary. Art. 83. The President of the Republic is elected by Parliament in joint session of its members. 3 delegates from every region elected by the Regional Council so as to ensure the representation of minorities. The Valle d'Aosta has 1 delegate only. The election of the President of the Republic is by secret ballot with a majority of 2/3 of the Assembly. After the 3rd ballot an absolute majority is sufficient. Art. 84. He can be elected President of the Republic every citizen who has attained 50 years of age and enjoys civil and political rights. The office of President of the Republic is incompatible with any other office. Compensation and endowments of the President are established by law. Art. 85. The President of the Republic is elected for 7 years. 30 days before the expiration of the term, the President of the Chamber of Deputies shall summon a joint session of Parliament and the regional delegates to elect the new President of the Republic. If the Houses are dissolved, or there are less than 3 months to their dissolution, the election shall be held within 15 days of the meeting of the new Houses. In the meantime, they extended the powers of the incumbent President. Art. 86. The functions of the President of the Republic, in any case that he cannot perform them, shall be exercised by the President of the Senate. In case of permanent incapacity or death or resignation of the President of the Republic, the Speaker of the Chamber of Deputies shall elect a new President of the Republic within 15 days, except for the longer term provided for if the Houses are dissolved or have less than 3 months to their dissolution. Art. 87. The President of the Republic is the head of state and represents national unity. It can send messages to the Houses. The elections for the new Houses and fixes their first meeting. Authorizes the presentation to the Houses of draft laws initiated by the government. Promulgates laws and issue decrees having the force of law and regulations. Call popular referenda in the cases provided by the Constitution. Appoints, in the cases specified by law, the officials of the state. Accredit and receive diplomatic representatives, and ratify international treaties which have, where required, been authorized by the Houses. Has command of the armed forces, presides over the Supreme Council of Defense established by law, declares a state of war decided by the chambers. It presides over the Council of the Judiciary. It may grant pardons and commute sentences. It confers the honors of the Republic. Art. 88. The President of the Republic, having heard the Presidents, dissolve the chambers or even one of them. It may not exercise this right during the last 6 months of his term, except when they coincide wholly or partly with the last 6 months of Parliament. Art. 89. No act of the President of the Republic is valid if it is not signed by the proposing ministers, who assume responsibility. The acts which have legislative value and those others laid down by law shall be countersigned by the President of the Council of Ministers. Art. 90. The President of the Republic is not responsible for the acts performed in the exercise of his duties, except for high treason or plots against the Constitution. In such cases it is put impeached by Parliament in joint session, with an absolute majority of its members. Art. 91. The President of the Republic, before taking office, an oath of allegiance to the Republic and to uphold the Constitution before Parliament in joint session. Art. 92. The government of the Republic consists of the Prime Minister and the ministers who together form the Council of Ministers. The President of the Republic appoints the President of the Council of Ministers and, on his proposal, the ministers. Art. 93. The President of the Council of Ministers and the ministers, before taking office, shall be sworn in by the President of the Republic. Art. 94. The government must have the confidence of both houses. Each house grants or withdraws its confidence through a reasoned motion and which is voted on by roll call. Within 10 days of its formation the government shall come before the houses to get their confidence. An opposing vote by one or both the houses against a government proposal does not entail the obligation to resign. The motion of no confidence must be signed by at least 1/10 of the House and cannot be debated earlier than 3 days from its presentation. Art. 95. The President of the Council conducts the general policy of the government and is responsible for it. It maintains the political and administrative policies, promoting and coordinating the activities of the ministers. Ministers are responsible for the acts of the Council of Ministers, and individually for the acts of their own ministries. The law establishes the organization of the Council Presidency and determines the number, competence, and organization of the ministries. Art. 96. The President of the Council of Ministers and the ministers, even if they resign from office, are subject, for crimes committed in the exercise of their functions, to the ordinary jurisdiction, subject to approval of the Senate of the Republic or the Chamber of Deputies, in accordance with the rules established by constitutional law. Art. 97. Public offices are organized according to the law, so as to ensure the good conduct and impartiality of administration. The regulations of the offices lay down the areas of competence, duties, and responsibilities of the officials. Employment in public administrations is through competitive examinations, except in cases established by law. Art. 98. Public authorities, in line with European Union law, ensure balanced budgets and public debt sustainability. Civil servants are exclusively at the service of the nation. If they are members of Parliament, they may not be promoted except through seniority. The law may set limitations on the right to become members of political parties in the case of magistrates, career military in active duty officials, and police officers, diplomatic and consular representatives abroad. Art. 99. The National Council for Economics and Labor is composed, as set out by law, of experts and representatives of the economic categories, in proportion as to take account of their numerical and qualitative importance. It is a consultative body for the houses and the government for those matters and those functions attributed to it by law. It can initiate legislation and may contribute to drafting economic and social legislation according to the principles and within the limits established by law. Art. 100. The State Council is a body of legal and administrative advice and protection in the administration of justice. The Court of Auditors exercises preventive control over the legitimacy of government measures, and also subsequent control on the state budget management. He participates, in the cases and ways established by law, in auditing the financial management of the entities to which the state contributes in the ordinary way. It reports directly to the Houses on the results of audits performed. The law ensures the independence of the two bodies and of their members in front of the government. Art. 101. Justice is administered in the name of the people. Judges are subject only to the law. Art. 102. Judicial proceedings are exercised by ordinary magistrates empowered and regulated by rules of judicial regulations. They cannot be established extraordinary or special judges. They can only be established within the ordinary judicial body's specialized sections for specific matters, including with the participation of qualified citizens who are on the judiciary. The law regulates the cases and forms of the direct participation of the administration of justice people. Art. 103. The Council of State and the other organs of judicial administration have jurisdiction for safeguarding before the public administration legitimate interests and, in particular matters laid out by law, also of subjective rights. The Court of Auditors has jurisdiction in matters of public accounts and in other matters laid out by law. Military tribunals in time of war have the jurisdiction established by law. In times of peace they have jurisdiction only for military crimes committed by members of the armed forces. Art. 104. The judiciary is an autonomous and independent of all other powers. The Supreme Judicial Council is chaired by the President of the Republic. Members by right are the First President and the General Prosecutor of the Court of Cassation. The other members are elected for 2/3 of all the ordinary judges belonging to the various categories, and 1/3 by Parliament in joint session from among full university professors of law and lawyers after 15 years of practice. The Council elects a Vice President from among those members designated by Parliament. Elected members of the Council remain in office for 4 years and are not immediately re-elected. They may not, while in office, be registered in professional roles, nor serve in Parliament or on a regional council. Art. 105. The High Council of the Judiciary, according to judicial standards, employment, assignments, and transfers, promotions and disciplinary measures of judges. Art. 106. Judges are appointed by means of competition. The law on the judiciary allows the appointment, even by election, of honorary judges for all the functions performed by single judges. Of the High Judicial Council they may be called to the office of cassation counselors for their outstanding merits, full university professors of law and lawyers with 15 years of practice and registered in the special professional lists for the higher courts. Art. 107. The magistrates are irremovable. They cannot be dismissed or suspended from office or assigned to other courts or functions unless following a decision of the Supreme Judicial Council, taken either for the motives and with the guarantees of defense established by the judiciary or with their consent.